Battle brewing here in California over medical malpractice. A proposed ballot measure would raise the amount of money a victim could receive for emotional injury to more than $1 million.
Supporters say it's necessary, but critics argue raising the cap would end up costing consumers billions of dollars. In tonight's Reality Check, Sam Brock looks at the claims and separates fact from fiction.
Raj and Janelle, good evening. This debate only applies to a certain segment of people who are seeking compensation for non-economic damages. That would be emotional pain, as you said, suffering loss of a loved one. Now, the measure's sponsor says he's not concerned about the impact on big business. He's concerned about access to attorneys for victims. And it turns out he's right. Access is a problem, but the costs and implications can't be ignored either.
And when you can't get to court, you're really victimized the second time, not only in the loss of your loved one, but then you find out you can't get justice on that doctor or hospital.
Bob Pack says the loss of his 2 children, Troy and Alana, almost 10 years ago to a drugged driver, misprescribed on a variety of medications, has forced him to become an advocate. Not just for the 7- and 10-year-old whose names are memorialized at this Danville Elementary School, but for the many other victims of medical malpractice who he says can't access a courtroom because the awards for such cases are capped so low, attorneys won't take on many clients.
In the case of a death, this is the worst element of all because in reality, you get nothing. You don't get the $250, you get zero because you can't get to court.
Here's what he's talking about. In California, medical malpractice awards are divided into 2 categories: economic damages that have no cap and are directly tied to things like lost wages and medical costs, and non-economic damages that have a cap of $250,000, which was created in 1975, and cover suffering and emotional pain. So what does $250,000 mean today? In terms of inflation, its modern-day equivalent would be $1.1 million. That's the increased cap that PAC is seeking. But its buying power, in reality, in today's dollars, is actually about $57,000. For many attorneys, that sum doesn't make much business sense.
I get calls from people who've spoken to many lawyers, and I turn down about 49 out of 50 people who call me.
Boone Calloway is a San Francisco malpractice attorney with more than 20 years of experience. He says he'd like to represent more people with valid claims, if he could.
Many cases that go through trial incur costs of over $100,000, and that's money that comes out of my pocket that I will never get back unless we win.
So the idea behind this measure is to make it easier for attorneys to take additional legitimate cases. But for doctors providing general care in communities like San Ramon or in Oakland clinics that provide treatment to anybody regardless of their ability to pay, those doctors say a higher cap means an invitation for more frivolous lawsuits and more money for lawyers, which would negatively impact the entire healthcare system.
Everything I've read indicates that costs would go up, and when costs go up, it comes from somewhere, and it would be access to care for patients.
As a doctor, I care about all my patients, and no less if they've been harmed. But looking at the broader picture, looking at the healthcare system as a whole, the best way to provide the best care for the most people is to devote the resources we have to providing care rather than diverting it into the legal arena.
And the risk of higher health care costs are very much real. We're going to be investigating those in the coming days. But will raising the cap right now mean more malpractice cases here in California? We compared the state's 5-year average of payouts and settlements per capita of 100,000 people, which is 3.6, to states throughout the country without any caps, like New York, which you see right there. Their average is nearly triple California's. But Arkansas, down in the south, their rate is a full point below ours. Then you have Washington State here in the western region. It's about the same as California's. So it looks like caseload might be as much a function of region and state law as anything else. Now, access is an issue. We heard from an attorney who's rejecting 98% of his client offers, so that claim is true. But an explosion of frivolous lawsuits, that data that we just showed you indicates the statement is possibly true, but it's highly speculative. I'm Sam Brock. That's today's Reality Check. Let me send it back to you.